So friends, the next topic that we're going to be studying about is known as discharge or termination of contracts. That is, how does a contract come to an end? A contract can come to an end in any one of the following activities. That is, if the contract is performed. Because remember, the purpose of entering into a contract itself is to do some performance, is to do some kind of activity. So once that activity is completed, then we can say that the performance of the contract is completed. So let's look at some concepts of performance. It is sufficient that the promisor performs his side of the contract. If the performance is rejected, then the promisor need not actually perform his contract or may even sue for breach of contract. So what do you mean by performance? If one party to the contract is willing to perform his end of the contract, that is, he is ready to sell his goods to the buyer, but then the buyer refuses to buy it, or the buyer breaches the contract, then the seller need not perform the contract. In fact, he has another right, that is, he can even sue for breach of contract. So to be valid, a tender must be on the following conditions. 1, it must be unconditional, must be made at proper time and place. It must be in a certain circumstance that allows the other party by whom it is made is able and willing to do the entire contract, especially by his promise. The tender must relate to some delivery of goods, and there must be a reasonable opportunity of seeing whether the person is ready to perform his contract. And the tender was made to several joint promises and has the same effect of a tender on all of them. So the tender of performance is entirely dependent on understanding who is capable of performing the contract. Then the next thing is by mutual consent or agreement. That is, if both parties bring an end to the contract, it is done. Lapse of time. If the contract was to be performed within a particular time and that time has lapsed, then we can say the contract is discharged. By operation of law, impossibility of performance and of breach of contract. Because whenever there is a breach of contract, generally they will say that the contract will stand terminated. So friends, who can demand performance? Generally, the parties to the contract only can demand performance. But a stranger to a contract cannot sue. What do you understand by joint liabilities? When 2 or more persons have made a joint promise, then essentially both persons will have to perform the promise. If there comes a situation where one of them dies or is not able to fulfill the promise, then the legal heirs will have to take on the contract and perform it. The next concept is known as assignment. An assignment is a case where you are handing over the rights and benefits of the contract to the third person. An assignment is always to be completed only when it is in writing. The next one is by discharge of mutual agreement or consent, as we had already seen, where both parties agree to bring an end to the contract, then they can bring an end to it. It is done in the process of novation, alteration, rescission, remission and waiver. Novation is a part where almost a new contract is substituted for the existing contract. Alteration is where some material terms of the contract have been altered. Rescission is that before the actual performance of the contract, the parties may agree to take the presumption that it has been discharged. Remission means that from the sum that is agreed in the contract itself, a lesser sum is allowed to be paid. And waiver is a case where a certain right is being waived in favor of the other party. We have seen what discharge by lapse of time is. That is, if the contract requires some time to be discharged and it doesn't happen within that time, the contract comes to an end. Discharge by operation of law, by merger. That is, where this contract is submerged with a superior contract. by unauthorized alteration to a written document, by insolvency processes, and by impossibility of performance. The next is discharge by breach. So wherever there is a breach of contract, they will say that there is an end to the contract. Breach can be actual or anticipatory. If there is an actual breach, then the contract comes to an end. But then an anticipatory breach is one which allows the party to presume that yes, there could be a breach of contract in the future, but may take the necessary steps to wait until the breach has actually happened. What does this mean? Say for example that there is a contract between two parties, A and B. Now B has agreed to supply goods for a period of 1 year. But then 3 months into the contract, B's factory catches fire. So if B's factory catches fire, then there is a very strong assumption that he will no longer be able to supply the goods to A. Now at this point, A can take any one of two decisions. He can presume that since the factory has caught fire, B will be unable to supply the goods to him. He can treat it as a breach of performance. Please remember that breach of performance happens only when the performance is due. That is, on the 1st of every month, the supply should have been made. So until it becomes the 1st of every month, then we cannot say that there is a breach of contract. So the 1st of every month should come, and if on the 1st the goods don't reach A, then we can treat that as a breach of contract. But then anticipatory breach is saying that even before it touches the 1st of the next month, say for example the fire took place on the 3rd of the month, 3rd of the previous month. So the next supply is due only on the 1st of next month. And at this point, A can presume one of two things. A can presume that B will be unable to perform and treat it as a breach of contract. But A can also presume that no, B had multiple factories, that he will still be able to supply the goods to me from a different factory. So he can wait till the actual date where performance is due, that is the 1st of the next month, and then if the performance does not happen, that is if B does not supply the goods, then A can actually sue for breach of contract. So anticipatory breach works in such a way where one party knows that the other party is not going to be able to perform, but he can give time, because he can give time till the performance is due. If till the performance is due he gives time, then there is a chance that the other party may be able to revive the contract. So this is what we call as anticipatory breach of contract. The next concept is remedies for breach of contract. So the remedies for breach of contract is that when either one of the party ends up breaking the provisions of the contract, then the injured party can rescind the contract. Rescind meaning they can actually cancel the contract before the performance is due. They can sue for damages, specific performance, injunction, and sue for quantum merit. So let's look at damages for breach of contract. Section number 73 says that any person who has broken the contract, then the suffering party who is entitled to receive some kind of compensation for any loss or damage caused to him must receive that loss or damage, in the sense that no person should be allowed to enrich himself at the delay of the other. Let's look at the case of Hadley versus Baxendale over here. There was a mill, and in that mill a certain part crucial to that mill had broken down. So he delivered that shaft to a common carrier, that is a courier service, to be taken to the manufacturer and make a new one. Now, at this point, A did not let B know, that he did not let the courier know that if there was delay, there would be loss in profits. Now, what had happened was the part itself took some time to be completed and given back to the mill owner. As a result, the mill was idle for a very long time, and there was a loss of profits. Here they held that B was not liable for loss of profits because he did not communicate to A that if you take too much time, then there will be loss of profits to the mill. So the court went on to say that there is a necessary requirement to show that you had communicated this to the other person and then that person took an inordinate amount of delay. Now, when we look at damages, there's something known as unliquidated damages, ordinary damages, special, exemplary, and nominal. Let's look at what they are. Ordinary damages are those damages which can be the estimated amount of loss actually incurred. So these are situations where the injured party has actually suffered some kind of a pecuniary loss and he has to be paid out for that loss. Special damages are those damages which arise out of some peculiar circumstances. Okay, so let's say for example, A delivered goods to the railway to be carried to an exhibition, and he told the clerk that if this painting did not reach within the specific time, he would suffer loss. The goods reached late, and hence A was entitled to claim special damages. Exemplary damages are only given as a punishment to punish the defendant, and they are in cases where there is a breach of promise to marry and a wrongful dishonor of check. So what is this exemplary damages? They are merely given simply to punish the defendant as a sort of a penalty of sorts. And nominal damages are those which are given only for the sake of saying that okay, this decree has been issued. So the damages will be very small. In fact, it might even be just 1 rupee, 10 rupees, 25 paise, etc. Liquidated damages and penalty. Sometimes the difference between liquidated damages and penalty may not be very different. But then the difference between liquidated damages and penalty is that they're saying that in case there is a breach of contract, liquidated damages will be allowed. But then if the purpose is to punish the defendant, then we can call it as a penalty. The next remedy is your specific performance. Now, in some situations where monetary compensation is not an adequate remedy, or the court cannot supervise the execution of contract, or the contract is for personal service, or one of the parties is a minor, then the court will believe that okay, rather than granting damages, I will simply grant specific performance. What is specific performance? It is the court will insist that the parties carry out their agreement. If any one of the parties fail, then the defendant may be allowed to carry out the performance in accordance to the terms of contract. The next and last remedy is the case of injunction. So we have already studied about what an injunction is when we studied our civil procedure code. It is an order restraining a person from doing any activity. So the purpose of damages is to provide compensation. The purpose of specific performance is to ensure performance of the contract when the remedy or damages is not sufficient. Whereas an injunction is known as a stay order, or it's telling a person stop doing something. So the court will restrain the commission of a wrongful activity and as well as the wrongful commission. So the purpose is that in an injunction you stop the wrongful activity, balance out the convenience between the two parties, and then arrive at a situation where the court will be able to determine whether there has been some breach of contract or not. So friends, this is the end of breach of contract. That is, you have damages, you have specific performance and injunction.